Okay. All right, we're back, everybody. Next on our agenda, Nicole Brown, DeRocher boundary relocation exemption request.
Thank you, Chairman Fulford. Commissioners, Nicole Brown, Broadwater County Community Development Director and Planner, presenting the DeRocher boundary relocation request. Mr. Roland DeRocher is here present in the room. So if you have questions at the close of my presentation, I'm certain he would be happy to answer those questions. These documents have been posted on the website. The certificate of survey for the proposed boundary relocation request, the affidavit, as well as my staff report. So with that, I will read my staff report into the record.
Okay.
This is a boundary relocation request from Mr. DeRocher. The deadline for this governing body to take action is January 3rd, 2024. The applicant is Mr. Roland DeRocher. Executive summary. The exemption request, as presented to the Broadwater County Commissioners, is a proposal to amend 5 lots utilizing a boundary relocation exemption. Mr. DeRocher is proposing a boundary relocation between 5 properties, all under his ownership. On December 30th, 2019, Neil Boma filed a greater than 160 acres exemption survey, creating 7 parcels greater than 160 acres. On December 4th, 2020, Neil Boma filed a family transfer exemption on these properties, creating 2 additional tracts for gift to his immediate family members, 1 parcel to each of his parents. On January 7th, 2021, Mr. Boma filed a boundary relocation for a portion of these properties. The family transferred lots were not boundary relocated. Mr. DeRocher purchased all of these properties from Neil Boma on May 7th, 2021. With the submittal of this boundary relocation exemption request, Mr. DeRocher is proposing to relocate the boundaries of 5 of these established parcels to align with Ridge Road. 2 of the parcels are mining claims and are being boundary relocated in their entirety to allow for direct access onto Ridge Road. Boundary relocation statutes. Montana Code Annotated 763207-1A provides for divisions made outside of platted subdivisions for the purpose of relocating common boundary lines between adjoining properties. Montana Code Annotated 764103 provides sanitation exemptions for parcels greater than 20 acres in size, exclusive of public roadways, are not subject to Department of Environmental Quality Review. All parcels will continue to be greater than 20 acres in size if the use of this exemption is approved. Request. The owner of these parcels is requesting approval of the use of the boundary relocation exemption. Location. The properties are located off of Ridge Road in sections 11, 13, and 14, Township 6 North, Range 3 East. These properties are approximately 10 miles southeast of the city of Townsend. Existing development and uses. All parcels are currently being utilized for rangeland. Adjacent land use in all directions is agricultural. Project uses. Wastewater. All parcels are and will continue to be subject to review and/or approval from the Environmental Health Office and subject to 1736-9 of the Administrative Rules of Montana. No septic systems are installed on any of the parcels. Since no new parcels nor structures are being proposed, there will be no additional review required by the Broadwater County Environmental Health Officer other than to ensure the appropriate sanitation exemptions are cited on the proposed COS. Access. All properties have direct access to Ridge Road, a county road. If any additional approaches are to be constructed, they will be required to apply for a county road approach permit from the Broadwater County Public Works Department. Ridge Road receives once annually road maintenance. Water. No residential wells are constructed nor being proposed at this time. Public health and safety. Because of the distance from the nearest emergency services building, particularly a fire station, and the proximity to nearby forested acreage, there is a danger of forest fires. Should these parcels be used for residential purposes, all future lot owners should be made aware of the steep terrain and oftentimes unpassable nature of Ridge Road in the winter months. No snow removal by the County Public Works Department occurs along this section of Ridge Road. There is also no school bus turnaround approximate to these properties. There is a high probability that much of these properties are in excess of 15% slope, which would render them unbuildable according to the Broadwater County subdivision regulations if this were submitted as a subdivision application. No structures are being transferred through this proposed boundary relocation. There is an existing 60-foot wide county road easement through these properties for Ridge Road right-of-way. Conclusion. Pursuant to 763207-1 MCA, which states, Unless the method of disposition is adopted for the purpose of evading this chapter, the following divisions or aggregations of tracts of record of any size, regardless of the resulting size of any lot created by the division or aggregation, are not subdivisions under this chapter, but are subject to the surveying requirements of 763401 for divisions or aggregations of land other than subdivision, and are subject to applicable zoning regulations adopted under Title 76, Chapter 2, Sub-Item A, which states, divisions made outside of platted subdivisions for the purpose of relocating common boundary lines between adjoining properties. And that concludes my report.
All right. I believe this is the first time we've ever had to work with a mining claim involved in boundary relocation, so might take us some time to work through this. All right, I'll start off with my fellow commissioners. What do you got?
I led the last time. No pressure, Debbie.
I'm not taking any pressure. Don't worry about that. There's a lot to learn on this, and we all did a deep dive.
This is probably the most creative COS or boundary relocation I've ever seen.
Chairman Fulford, I have a question.
Yes.
Chairman Fulford, I just had the question regarding specifically the two mining claims. And those mining claims, I had them up. I was going to try to read the right names. We're talking about the Commonwealth load claim, and we're also talking about the Independence load claim. And my question was, there was no evidence that I saw in this packet as to what maybe type of claim, or patented, unpatented. And I guess a follow-up question to that, Chairman Fulford, would be, was there a separate, you know, when you purchase a mining claim, I get it, you can buy a mining claim, but was there a separate buy-sell for the land underlying the mining claim, distinguishing that as a separate tract of record? Or was that underlying land just part of the original parcel of Parcel 2, which was 395 acres and some extra acreage? So that would be very informative, I believe, Chairman Fulford, as to what the status of those claims are.
I can answer those questions.
Yeah.
Perfect.
Okay, good. And I think one of our other, I have to pull it up on my phone so that I'm educating myself on the claims as well. Do the claims actually, the boundaries of the claim contain just the surface mineral rights, or do they contain the property itself? So maybe you can help us a little bit on that.
Certainly. Thank you, Roland DeRocher. I own them fee simple, just like any other property. They are patented claims, and I don't even have mineral rights actually to any of the property. That's already been stripped away as is common. So I bought them separately described as the 20.5 acre parcels. It was all the same transaction. I have 5, 6, 7 distinct parcels north of Ridge Road, and I had I think it was 7 more or something like that south of the road. That was primarily what Mr. Bama had done with his greater than 165s. I believe it's just the 2 in the northeast corner that were formed by that family transfer, and they didn't actually make sense to me to do it that way, but that's the way I bought the property. That was already approved and already officially part of the record. So now I own everything on that strip north of Ridge Road, and if I may, I have maps that I highlighted that I think make it easier to see what's going on.
Okay, yeah,
Oh, see,
sure. Thank you.
Okay, so the reason I'm doing this is I'm in the process of trying to sell the larger portion. So I've outlined in yellow all of my property, and you can see that there's the big one that, you know, looks kind of like Florida or something, or Indiana.
Indiana, there you go.
That's in red.
Yep.
And that's what I'm proposing to sell. And within that red block, actually there are two 20-acre parcels, which I own separately, and I'm selling that part of it. So those are the mining claims right in the middle. Those never had any easements or insurable access to them. And the larger portion there in section 11 actually doesn't have any access either, but for the parcel that is along Ridge Road, which is, I don't know, they have weird designations of like 2A is the big piece, and then it's like 6A or something for the boot part, the toe of the boot. So what I'm trying to do is, one, not sell that little bit that is now marked as parcel 9 in green. That is actually right now described with the parcel that forms the boot of that other property. And it adds no utility to that larger parcel whatsoever. You know, it's just a little patch of grass, and the primary utility of that property is that Grayson Creek goes through it, and there's some timber to the north end, and that's where the elk are. And so the rest of it, it's just sagebrush and a little bit of burned out trees from 25 years ago. And then way on the east end, it drops back into Grayson Creek. And so all of that kind of fits together. But just as part of the negotiations, the purchaser didn't want to buy that property, and I still own the adjacent property. So I'm proposing just to do lot line adjustments to make that one parcel, technically removing 3 of them and moving them over, but I'm just starting with 5 and ending with 5. But that way everything will have access. I can't even count how many times I've had somebody contact me out of the blue asking if I'd sell one of those mining claims. And like, no, I'm not going to give an easement, and don't want somebody, you know, putting a house right in the middle of my other property. And I couldn't even use the primary part of my property if not for owning the stuff along Ridge Road. And so this is the actual, I've, you know, dealt with some property. I've never done a subdivision or anything, but of all the land deals I've ever done, I've never seen a parcel take in such a weird chunk, this 27.57 acres out of another section. You know, it's kind of a Frankenstein map. If you look it up on cadastral, all these little shapes in there, and they don't really make sense. And so we're just trying to move the boundaries over. And yes, as the commissioner said, it's creative, but Matt Morris is a really smart guy, really knows his stuff, and I believe he's right. I did read the statutes and some of the case law myself. There's nothing wrong with being creative, and you know, those statutes are there to allow landowners to utilize their property in the way they see fit. And in this case, I'm trying to make utility out of what I have and what I plan to keep and what I'm in the, you know, process of trying to sell. We have a buy-sell agreement, but it's based on this platting of creating the one larger 2A and getting rid of the tag over there in section 13 that is in green, and just making that all one parcel, which would also protect it. Obviously, it would have to go through all of your rules if somebody wanted to later subdivide it.
Okay.
But legally speaking, in my legal opinion, there's no difference between the mining claims, which are patented, and how I own the other ones. It's all in fee simple.
Mr. Chair, I have a question.
Yes.
For Deputy County Attorney Minor, what was the difference on the patented versus non-patented mining claims? I can't remember.
Yeah, in short, Chairman Folkford, I'll address Commissioner Rickmeyer if I may.
Yes.
In short, you know, these patented mining claims have well, I can actually read the statute. It's under 82-2-113, the effect of a patent. The issuance of a United States patent for a mining claim is considered conclusive evidence that the requirements of the laws of the state relative to the location recording of such mining claim has been duly complied with. So that just is like, if you get a patent that says, no, you really do have this mining claim. It is really here. It is really in existence. Additionally, and this is where I was asking for the applicant for proof of this patent because I haven't seen it, and I would also like to see the legal descriptions that he is alleging exist for the separate 2 tracts of record for those, because that's really going to be informative as to whether or not this is a very creative amended location of a mining claim, which a mining claim under 82-2-107 says that you cannot involve a change in the point of discovery as shown by the discovery shaft. So I'm not quite sure how we're going to get from the original location of these mining claims to many acres away without making a change to the point of discovery as shown in the mining shaft. And then if he does not in fact have a patented claim, I do trust exactly what the applicant's saying. I just haven't seen the evidence myself. If it's an unpatented claim, it's a surface right only. It just kind of hovers on top, and you can just maybe do a little poke down, a little bit of exploration, etc. But if it's unpatented, there is no basis for it being a separate tract of record that could maybe be moved. And I say maybe because again, if we're dealing with mining claims, which we clearly are, I want to make sure this amended location and these statutes are followed.
May I comment on the statute?
Yeah, sure.
Those statutes basically go back to the Copper King fights where they would start a shaft and they could go anywhere they wanted. And that's how the third Copper King was created. He found a little tiny triangle of land in Butte, dug down till he hit a vein, and then just went right underneath the other guys. There is no known minerals on this property. There is no shaft. And so, we're kind of talking about irrelevant issues because there's no origin of a shaft to go anywhere on either of these properties.
I guess so the question in my mind is, so we're talking about these 2 lots that are out in the middle of.
Mm-hmm.
We're basically picking them up and moving their boundaries. That's my question.
Yes.
How are we doing that?
Well, if we were to break this down into a string of dominoes, there's no reason I couldn't expand that mining claim up to the edge of Section 13. And then I could stretch it all the way to the end of Section 13 if I wanted to. Then I could bring the end that's in the middle right back up to where it's part of one of the other ones. Just like technically there is a boundary running along the section line between Section 11 and Section 14. So the tip of the boot and the top of the boot are 2 separately described parcels. You can look them on the cadastral, and that large 2A is completely landlocked without owning the tip of the boot. And so I'm just moving that line because it's an individual parcel, and then the other 2 because they're individual parcels, so that now I get rid of 1 parcel and I have 4 left. I still am selling the same amount of land. I'm still keeping the same amount of land. I'm starting with 5 parcels and I'm ending with 5 parcels. And thank goodness I'm not involved in a subdivision with this after the discussion on the last hearing. But as far as I read the law and as far as it's been described to me, you don't just say, oh, well, you only get a little bit of adjustment. You can adjust it as far as you want within your own property. And since I own the property in that northern part of Section 13, I can move my boundary lines over there. That's how I view it, and that's how we've proposed the application.
Mr. Chair,
Yes.
can I ask
Yes.
you a question?
Yes, you may.
I'm Angie Paulson, Broadwater County Clerk and Recorder. I obviously deal with several mining claims in my office. My question, Mr. Chairman, is how does the Bureau of Land Management have they been consulted on this specific piece of property? And that's my question.
Okay.
Yeah. And the reason for that is any mining claim that comes through my office, we do not give legal advice on. We reference BLM and that Broward County customers need to discuss with them first. They have to go through
Sure.
BLM first.
Yeah.
Yeah.
Okay.
I guess what, excuse me, Mr. Chair, what, does BLM have a say-so if the mining claims can be moved? Okay, that's what you're saying. Okay,
That's the
okay.
question.
That's what you're saying they need, okay.
Yep.
Okay.
And it's my position, Mr. Chairman, that BLM has no control whatsoever once they're out of the hands of the federal government. There was a time, based on the title history, in the title report I got, that whole area belonged to the BLM, and I believe it was in the 80s that they started selling off chunks of it, except for, of course, the mining claims, which had already been divested from the federal government and patented, I believe, sometime in the 1800s.
So I guess I'm just, and maybe you can help me answer this question. That you say you have a pending buy-sell based on what happens here today.
Yes.
Apparently those people are not interested in the mining claim.
Well, they are interested in the property. They wouldn't buy it without getting that property, but they don't care about it being separately defined. They just want the chunk of property, and so they want the whole boot.
Right.
And so I could sell them 4 parcels, and I still wouldn't have dealt with the 27.57 acres that we agree doesn't really fit with that. They don't want to pay any more money, and I don't want to give them any more land.
Okay.
That's how our negotiations ended up.
All right. So they don't want to buy the mining claim parcels. Is that what you're saying?
They don't want to buy them independently. They don't care that it's all going to be one consolidated parcel. They do want the property, and I am intending to sell them the property, but it will be under a single described property and a single deed so that we don't have this mess anymore.
Okay.
It's, Mr. Chair, it's confusing because you think the ground is all the ground, right? And so then you have the 2 mining claims, which, like, I'm looking at it as like they're a perimeter, right? It's saying, here's the claim right here. This is where
Right.
the shaft was, or whatever the claim was designated. So there's like this perimeter that's imposed on the actual tract of land.
Kind of goes back to the point of origin as
Yeah, yes, it's the perimeter surrounds the point of origin. It's almost like you could move that perimeter around that point of origin, and it would make more sense. I understand what you're saying. Like, they want this tract of land, but they don't want the claim. But the claim's like kind of
Part of it.
it's part of it. It's part of the ground. The ground is there. You're not moving the ground. It's not a separate piece of ground.
But it is.
There's a perimeter that designates that piece of ground as being a special piece of ground that is part of the bigger section, right? That's kind of how I'm looking at it.
But they're all separately surveyed and described, and the clerk and recorder has all of that, that all of these properties are surveyed. They
Right.
are their own boundaries, yes. I just propose to change the boundaries, and realistically, once somebody owns a patented mining claim, it is no different than if it had been a homestead
Sure.
or something else, or the railroad had sold off one of their sections, or if you're Ted Turner, the state sells you one of their sections.
Yeah. It's just interesting. It's an interesting concept. It's something I've never seen. I doubt either of them have seen before.
Well, in fairness, I didn't come up with it. Mr. Morris did, but
Chairman
Keith's
Fulford?
done a lot.
Yeah.
I have a question, sir, and it's actually, it's a comment. Let's just call it what it is. The thing with boundary relocations is they're a division of land made outside a platted subdivision, check. Not a subdivision, to our applicant's point. But the purpose of a boundary relocation is to relocate a common
Right.
boundary. We do not have a common boundary line with regards to these two mining claim parcels. I trust our applicant that there is a separate legal title. I didn't have that information before this hearing. I'm sure he will provide it for it if it's requested. The biggest issue I see is that there's no common boundary line that is being relocated. It is essentially being picked up and moved. There's no common boundary line. His map is very clear. He handed you a map with yellow and red and green on it. There's no common boundary line. I do not believe without that common boundary line, we're adequately going into a boundary relocation situation, which is a subdivision exemption. This gentleman has made very clear that he wishes to clean up his map so that he can do a better buy-sell and that he can still have all these parcels down below. He can get that done through a subdivision request. This will be a minor subdivision. I see how many lots? 4 or 5 remaining lots. It would fall under a minor subdivision classification. And that would also get him the result that he wishes for. But in the absence of this common boundary line, I feel like but for a succession of surveys to move that boundary line, to make that boundary line common, we're taking a leap. It's a creative leap. I just don't think it's statutorily supported by 76-3-2071A, which is really what we're talking about as a boundary. Is this a boundary relocation, yes or no? And this can absolutely be achieved through a minor subdivision. And it just seems like he might be adverse to going to that process based on what he has stated previously.
And respectfully, I disagree with the counselor. All of these properties are in one giant lump. They all share common boundaries. Now, there's absolutely no doubt that I could take that border that is over there in section 13 and slide it to the west and enlarge the tract that I have there. I think we can all agree with that. That's a common boundary. There's no reason for that boundary to exist between the top and bottom of the boot. I could swing that down and cut off 50 acres or 100 acres. All I'm doing is swinging around that boundary. And same with the mining claims. I can stretch those, one at a time, but I think that that would be a rather obtuse way to do it, to try to say, well, we're moving this boundary now, and then we're going to come back and move the next boundary, and then we're going to move the next boundary. So there are common boundaries, and just because I'm shifting multiple boundaries doesn't change the fact that these are all commonly interspersed with one another.
Chairman Fulford?
Yes.
The common boundaries that the applicant's alleging, there is no common boundary with the current configuration of the Commonwealth and the independent load claim with parcels 8 and 9, which are the parcels that he is creating in the new proposed survey. I do not see. I see an expanse of acreage in between the two. So this common boundary it's an argument he is making. I just don't see it on the map.
Okay. So I guess would it be fair to say that we need more information to make a determination on this?
Yeah.
Mr. Chairman, I certainly do. We've done a deep dive, all of us, into mining for the first time ever, so I would appreciate.
Is there any precedent? Do we, anywhere in the
Well,
state? I wonder
Yes.
if there's some
I'd say
Chairman
there is,
Fulford,
Yes.
would you like to discuss
Yes,
that, too?
please.
The sanitarian weighed in on,
Yeah.
in the past, this has actually not been allowed.
Okay.
And that's coming from the sanitarian. The concerns were the lack of a common boundary, which is what's normally relocated. And these mining claims do not share a common boundary with the parcels that they will become. They will, in a sense, they won't just shift over. They will full on move. Is what the contention is. And but for a series of surveys documenting that move in succession, that is what has happened in the past typically, Chairman Fulford. And that's from our sanitarian, who is obviously on the certificate or the COS committee.
Okay.
So I would respectfully ask that this be added to next week's agenda. I don't know. Gives us at least a few.
Is that enough time? Is that enough time? When is, excuse me?
The deadline's January 3rd,
January 3rd, is that the,
which is,
Chairman Fulford, yes, the deadline for action on this is January 3rd. So to my knowledge, you still have 2 commission meetings prior to that date. Oh, so not the 23rd. I'm sorry, the 18th and the 23rd, which is a
If we-
Monday.
if we had a meeting on the 23rd.
If you had a meeting on the
Monday.
23rd, correct.
Wednesdays are a normal day. We could-
Wednesday's your normal day, but that will be the 25th of December, and
Right.
we will not be here. So that the commission has the 18th and the 23rd available commission meetings still to discuss this and take action.
all right. All right, Mr. Grosch, are you opposed to us taking some more time to research this?
Your Honor, again,
There you go.
Mr.
You are an
Chairman.
attorney, okay? I
Yes.
thought you said that.
So,
Yeah, and there's 3 of you. The only time I've had more than one is when I've gone to the Supreme Court, so. Obviously, it is your prerogative to do that, and I'm not going to object to you doing things the way you see fit. If I may get some advice, however, while we have everyone together,
So I
If-
think we needed the proof of patent.
Yeah.
We need that information. And I guess, is that the legal title you're talking about?
Legal title, legal description is helpful in understanding exactly how those mining claims are actually in existence.
Yeah, we need to determine if a point of origin can be moved. And I mean, those are the things that I've wrote down. I know there's some other questions that we have here. I think in our minds, we need to determine for ourselves if there is a common boundary.
may I throw something out that
Yes.
could alleviate everyone's concerns on this? So if we look at this, I did not mark this boundary, but that is a boundary, you know, between the top and bottom of the boot.
Mhm.
If, may I approach?
Yes, you may.
So if.
We're not in court, but you can.
Well, habits, you know.
I know
So
that.
if I take this line here and just swing it down here, so that I am making that all one parcel, and then this parcel just becomes the 27 acres, this is all then one piece, does that take away the stress over the
Can you
mining
show that
claims?
again?
yeah, say it one more
Sure.
time, but yeah, it
Okay.
makes more sense,
So,
but yeah.
this is all one parcel, including the green.
Right.
If I were to take this line and just shift it down here, then this parcel becomes part of this parcel, and then this is all that remains of the tip of the boot.
Right.
Yeah, I mean,
That's what I actually proposed to the,
sorry, you said,
So this is all-
this piece would like shift, it would just
So-
go like that.
correct,
I
because
see.
this is a parcel and this is a parcel, but this is part of this parcel right now.
Yes.
So I could just cut off this parcel to make it smaller here by moving this line, leave the mining claims alone.
Mhm.
Yeah, that
It-
sounds like it'd be way,
Yeah.
Okay,
way more.
Yeah,
if I
simple.
can get that,
Oh my
Show that,
gosh.
show that to Kaylin, please.
Yeah.
That's me.
Meg, ground.
Sure, whatever you need, yeah.
Way more sense.
Okay, so all I'm saying is, this is currently one parcel, including the green. This is a boundary line. If we shift this boundary line down here, this parcel just remains there. We don't touch the mining claims. I can move forward with my deal, and then you don't have to, get into a fight with me over who's right about the legalities of it.
I'm happy to read case law, I just don't see where this has a common boundary with where it's going.
Well, it's all in how you define it, and you and I disagree on that, but you should be used to that with other attorneys.
So
You
weird.
can amend your proposal however you see fit, sir. That's 100% your prerogative.
All right, let's do that so that we,
All right, so I am,
That's a, excuse me, Mr. Chairman.
yes.
That's you can amend it if you choose. That's not a guarantee of a response. Yes.
yes.
Pre-approval.
And I am not withdrawing my original application at this time. I am just trying to see if we can find some common ground where it makes it easier for everyone.
Yeah, I think we have some questions we need to answer on our side, and
Okay.
so.
In regard to the descriptions and proof of patent, is that coming from me or coming from the clerk and recorder?
You.
Okay.
Sorry.
No. It is in no way Chairman Fulford, Angie's job to do the research.
And I guess I'm asking everybody involved, can we get this ready to go on October?
December,
It's all right. We're still there. It's happened.
December 18th.
December 18th. Because if we have a meeting on December 23rd, there will only be two of us, two commissioners.
Mr. Chair, may I ask? I cannot talk today. Director Brown, a question.
You may.
Director Brown, should our applicant resubmit, that would technically restart the clock. But right now, for the 18th, we would be focusing on his current application, correct?
Mr. Chair, may I respond?
Yes, ma'am.
So absolutely, Commissioner Rickmeyer, the way I hear this, the applicant, Mr. DeRocher, is not intending to resubmit anything at this juncture. He's not withdrawing his application. So we will continue with this application. And what you're asking for from him, if I'm capturing this appropriately, is a proof of, and all of these materials, will be provided by the applicant. The staff will not be doing any additional or further research. So pointing back to the question, does it allow enough time? This really is a question to reflect back to the commissioners. We're not putting a timeline on when Mr. DeRocher has to provide these items. You are the ones, you commissioners are the ones who are going to have the time to review and assess the information that you're receiving.
that's
So
my
does
point.
the 18th give you enough
That's
time?
my point.
Okay, thank you.
I don't know if we have the time to do that by the 18th, so.
It's a fair amount of information you're
It is.
requesting. If I may, Mr. Chairman, the way that I have captured this, what you're requesting from the applicant is a proof of patent for both mining claims, the determination of whether or not the point of origin can be moved, and then thirdly, determine if a common boundary is being moved. So maybe a narrative or a description from the surveyor or the applicant would be prudent at that juncture. But I just want to be very clear that no member of Broadwater County staff will be providing providing this information or doing any further research, because as Ms.
But along with that, there's still the question, is there a common boundary?
Correct, and that's one of the questions that's being reflected back to the owner of the property. So the question, to repose the question to you commissioners, as you pose the question, does the 18th give you enough time? From staff, myself's perspective, I would say no. That does not give you enough time. It does not give the applicant enough time to pull together those materials and you enough time to evaluate the materials.
I agree. I agree.
But the clock-
October, so.
But the clock is definitely not stopping at this juncture. There's no stopped clock, because this is simply a request for additional information. But should Mr. DeRocher decide to proceed in another fashion with a new configuration of boundary relocation, that would be an entirely new application. This would not be refunded, as we spoke to earlier. The work has already been performed, so this would be an entirely new application for a boundary relocation. Did that answer all of your questions?
Yes.
Yes.
Okay.
Yes.
I would like clarification on that, if I may,
Yes.
Madam Director.
go ahead. Sorry, you have to pose your question to Mr. Fulford, and then he will allow me to respond.
Okay. Mr. Chairman, would you ask the director, please, to tell me if an amended application is something that's allowed within the rules as opposed to needing to submit a new application?
Okay. Cool.
I'm going to make the assumption you'd like me to respond, sir.
Yes, sure.
Perfect. Formalities. Mr. DeRocher, no, there are no provisions in our current exemption claim form process per the Broadwater County subdivision regulations for an amended affidavit. It would be an entirely new submittal of an application.
Thank you.
You're welcome.
Right. So I guess that'd be a decision on your point of which direction you want to go.
Yes. And in all candor, that is what I anticipate, but I would like to consult with the surveyor
Yep.
and whatnot.
Yeah.
You know, I don't want to make anybody's lives more difficult. I just want to get the deal done.
Right.
And
Go ahead and come up here. And the other thing too is we don't do it to make your life difficult
No.
either. We just want to make sure that you don't get challenged in the future, the decisions that we make, and we want to make sure that we're following our process correctly.
I appreciate that.
Yeah.
And I would not want any of your jobs.
All right, anything else from anyone? No?
I have nothing further.
Thanks for making the trip down here
Yes,
today.
thank you all for your time. I really appreciate it.
Of course.
Okay, so just to be clear, we are waiting for, as a request for additional information, or if Mr. DeRocher chooses to proceed a different direction, he will submit a new application. That's correct? Everybody agree with that? Okay, thank you very much. All right, next on the agenda, Swenson Family Transfer Exemption Request.
Chairman Fulford, members of the board, Nicole Brown, Broadwater County Community Development Director and Planner, presenting the Swenson Family Transfer Request, Exemption Request, excuse me. Ms. Bernadette Swenson is here in the room to allow you the opportunity to swear her in at the close of my presentation of my staff report, which you should have in your possession, as well as a proposed certificate of survey and the affidavit. So with that, Mr. Chairman, I would like to read my staff report into the record.
Okay, thank you. Proceed.
This is a staff report for the Swenson Family Transfer. The deadline for this governing body to take action is December 27th, 2024. Again, giving you 2 additional meetings should you need them. The applicant is Bernadette Swenson. Executive summary. The subject property is 6.45 acres in size with access from Jack Farm Road, which is a county road. The parcel is currently owned by Bernadette Swenson, whom is requesting to utilize the family transfer exemption to gift a 3.40 acre parcel identified as amended tract B1 to her husband, Danny Swenson. Family transfer statutes. Montana Code Annotated 763207-1B provides for a division outside of a platted subdivision for the purpose of a single gift or sale in each county to each member of the landowner's immediate family. Since these 2 parcels will become less than 20 acres in size, they are both subject to DEQ review and approval, even though there is an existing home site on tract B3 with DEQ approval. Request. The owner of the parcel is requesting approval of the use of the family transfer exemption. No, sir. Sorry. No, you're fine. Location. The property is located off of Jack Farm Road in Section 32, Township 7 North, Range 2 East, Broadwater County, Montana. Existing development and uses. There is 1 existing home site on the parcel as well as a dry barn. Adjacent land use to the north and east are residential, to the south is agricultural, and to the west is residential. Project uses. Wastewater. Both parcels will be subject to review and/or approval from the Department of Environmental Quality under the Sanitation and Subdivisions Act, Title 76, Chapter 4, Part 1, MCA. The existing home site has an approved on-site wastewater treatment system that was approved by DEQ, but will need to be submitted to DEQ for a rewrite since the acreage of the parcels is proposed to change. Access. The property is located south of Jack Farm Road. Tract B3 has direct access to Jack Farm Road, and the amended Tract B1 will utilize a shared driveway easement across Tract B3. No additional approaches are being proposed at this time. However, should additional approaches be desired by the landowners, they will be required to apply for a county road approach permit from the Broadwater County Public Works Department. Water. There's an existing exempt well for the home site. The provision of water for any future development will be subject to review and approval by the Department of Natural Resources and Conservation, utilizing the exempt well requirements for a residential structure. Public health and safety. The proposed division has the potential to have adverse impacts on public health and safety as follows. Number 1, no fire protection is located in the vicinity of the subject property. The nearest fire protection system is located in the town site of Townsend. Number 2, since there is no review by the Townsend schools, there is no consideration for a school bus turnaround, which could pose a safety hazard for any future students. Conclusion. Pursuant to 76.3207(1)B MCA, which states under Title 76, Chapter 2, unless the method of disposition is adopted for the purpose of evading this chapter, B. Divisions made outside of platted subdivisions for the purpose of a single gift or sale in each county to each member of the landowner's immediate family. Broadwater County Subdivision Regulations 9CIB3 identifies an immediate family member as a spouse, child by blood or adoption, and parent of the grantor. According to supplemental information provided by Bernadette Swenson, the intent of this family transfer is to allow her parents to construct a home on the parcel and be closer to her and Danny. Given Bernadette's parents' health concerns, it seemed prudent for Mr. and Mrs. Swenson to maintain ownership of both parcels, as they do not want to risk losing ownership of either of the parcels. However, the separate parcel will allow Bernadette's parents the ability to utilize the separate tract for financing and taxation purposes. Neither Mr. and Mrs. Swenson have any plans nor desire to sell either of these parcels. There is an existing 20-foot wide private access and utility easement along the western boundary of Tract B3 that will serve as the driveway access to the proposed amended Tract B1. There is a proposed well and 20-foot wide water line easement on Tract B3 that is being created via this survey. Lastly, there's an 80-foot wide ditch easement for the Deep Creek Ditch that runs along the eastern boundary of both Tract B3 and amended Tract B1. And that concludes my report.
Okay, thank you. All right, let's lead off.
Chairman Fulford, I have a question.
Sure.
If the purpose of this family transfer is to make it so that financing for, I guess, building of a home can be obtained by, I think, the elder Mr. Swenson, was there any consideration ever to a mortgage exemption for an alternate way to get financing, and that actually wouldn't create a separate tract as long as the mortgage wasn't defaulted on? That would be another subdivision exemption claim, Chairman Fulford. Oh my gosh. I was just wondering if there was any information to that. I had not seen that in the packet.
Thank you for that. All right.
What a rough day you guys have
It's a
had.
rough one. Yeah, it's a
And then
rough
I
one.
come.
Yeah.
Bernadette Swenson, SWENSON.
All right. I'll go ahead and swear you in, Bernadette. Do you solemnly swear and affirm that the testimony you're about to give regarding the Swenson family transfer exempts is the truth, whole truth, and nothing but the truth?
Yes, I do.
Thank you very much. Okay. I guess maybe we'll start with Kay's question, huh?
Yes, and for a little background, you know, we started this process earlier this summer. We're very unsure of what exactly the plan is going to be, and so this was going to be a future decision. In light of the election and all, I just felt it was prudent to come before the board now. We decided to do the family transfer because of not knowing. Yes, we did consider a mortgage survey, but it isn't just for financing. It's mainly to protect my mother and father. When they sell their home and they build out there, we do not want to give ownership of land to them because, there's a lot of different things to consider with age, nursing home care or, that sort of thing, and we do not want to risk losing ownership of it. So our intention, and that's the reason why we decided to family transfer our home to Dan, because we're not going anywhere. But having that parcel separated allows us to put it into a trust or something. I want my mom and dad protected also if, heaven forbid, something happened to Dan and I. And they were living out there. I want them protected also. So our goal is to, continue ownership of our home and live there, but have that parcel separate that we could put into a family trust that my mom and dad are a part of, or that sort of thing. Or I may just continue ownership of it. We're exploring all different options. But the best option for us right now was to have it separated so that when mom and dad go there, it was a separate piece. Like I said, not only for our protection of not losing it, but their protection once they're living there.
Mr. Chair, I have a question.
Yes.
For Bernadette. So are they, I guess, my mind go, again, all the things we're considering, right? And you're well aware of all the things we
yes.
consider, okay. You need there to be a separate track in lieu of just like building the home, providing their needs, further needs, whatever, as they move there. Do you need it to be a separate tract? Does it have to be a separate tract, or why not just build them a place to live? I guess that's...
We're just trying to cover all bases. I guess in my line of work, we see all kinds of things that happen. And say we did do that, and heaven forbid something happened to Dan or I, I can't say what's going to happen to our land. Whether we left it to the kids or, there's just a million things that could happen, and I don't want them to risk losing their home because something, Dan and I happened to us or something. So that's why if, we can protect it into a trust so that they're separated and protected against our ownership.
Okay. Gotcha. Thank you for your letter, by the way.
Oh, no problem.
I just appreciate.
Like I said, I
people
deal with
take that
this
extra
enough,
time.
and I wanted full disclosure of, this is our plans, and, we're just beginning to look into all the different aspects of revocable trusts and irrevocable trusts and all that. But, I know there's, if someone gets put into a nursing home, you have to sell your property before your Medicare will take over. There's just a lot of things to consider. And not only for them, I mean, I'm getting right up there too, right behind them.
Thank you, Bernadette.
I have a question, Mr. Chairman.
Yes.
Bernadette, since you said you're not sure what you're going to do exactly, build them a house or set up a trust or whatever, why not wait until you are sure? Because once you do this, it's done.
Right. Well, we were going to go ahead and set it into the, a trust or whatever. And I didn't want to come back in 2 years and ask for a family transfer when I have a family member on the commission. And, ultimately this is what we were going to do. We were just, going forward till that time. There's no option of, what we are going to build back there, a small home, which mom and dad will have a lot of cleaning out to do. you know, so I mean, the home is going to go there, and whether it's this summer or the next summer that they move into, you know, we're just trying to get our estate together and involve them.
Okay. I guess my only question is going to be looking into the future, past you and your parent, or maybe your parents. Are you going to be okay with still sharing that proposed well easement? But more importantly, the driveway easement that other folks having to drive through your past
Yeah,
your
that's
house.
behind the barn. Well, and, you know, that's a big guarantee of that, you know, in my lifetime, this is not going anywhere else. For mom and dad, it's fine. But, you know, I have to say, you know, we had another child asked to build back there. And I said, we told her no, you know, we would not, which was hard because we did one for our other daughter. But I said, you know, you're young and I don't want to give you ownership because I don't want that to ever sell in the future and then be, you know, have strangers living back there or sharing a driveway easement. But, you know, so that's why I think if we'll get this down and then put into a trust so that it's in the family, but it protects mom and dad also.
Okay.
Mr. Chairman, I have a comment, I guess more than a question. And it's not specifically about this situation, but all these family transfers that we deal with, we don't get an opportunity to deal with the effect on the schools or the roads or any of that. And it could, at some point, have an influence on schools, roads, et cetera, et cetera. So I guess that's just my editorial comment.
Any other questions or comments?
Chairman Folkford, Kalen Minor, Deputy County Attorney. I just want to say that, you know, these arguments that we've seen before, the governing body before, about whether or not they put something in trust, that is absolutely irrelevant to your decision.
Right.
And what they choose to do with their trust is between them and their trust attorney. And so I do not see anything that would prevent them putting their entire property into trust, regardless of how many homes are on it. So those financial arguments really need to be parsed out, and really what they're asking for is a creation of a separate tract of record. And that is the issue, and so I just don't want to have any sort of confusion. If they want a separate tract of land that will ultimately be eligible for sale within 2 years, then this is appropriate. If they want a way to get money to build on it, then that's a different request. Or maybe it's the same request and it's just, you know, how they get to it. All this trust stuff is really, that is not something that needs to be considered.
Yeah. I guess one question, maybe either Nicole or Bernadette, was this lot, how was this lot originally formed?
This lot was originally formed by the division of the drainage ditch. They did a boundary relocation. I don't know, the year was before we owned it. The lands northeast of the ditch were boundary relocated to Mr. Walsh, owned land there at that time.
Okay. That was in 2003, right?
Yeah, I somewhere right around the early 2000s.
And then, I guess, was there another sold parcel, tract B2? Was that done by was that the family transfer that in 2017?
Let me look at my map.
Track what? Oh, B? B2.
Yeah.
Yeah, in the north west corner. Yeah, I believe that was a family transfer to my daughter.
Okay. Right. then track B1 that that you're asking to be created is formed by another family transfer, correct?
Correct, yes.
Okay. All right. All right, any other thoughts, comments, questions?
No.
Okay. All right, anything else? Okay.
Nothing, sir. I think I've pointed out what the real legal issue is here today and the decision that you guys have before you. And the commission obviously is well aware of the criteria for review, and I'm sure you all have considered that. Thank you.
Okay. All right, is there a motion?
I move to approve the Swenson Family Transfer Exemption Request, Section 32, Township 7 North, Range 2 East.
I'll second that.
Okay, motion's been seconded to approve the Swenson Family Transfer Exemption Request, Section 32, Township 7 North, Range 2 East. Any public discussion? Any public discussion? Any public discussion? Okay, all those in favor signify by saying aye.
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 Any opposed? Any abstentions? Yes.
Thank you, Commissioners.
Thank you, Director Norton.
I haven't been able to call you by your appropriate title all day. I apologize.
I think it's
It's the first time I did.
Thanks, Bernadette.
You too, Bernadette.
All right, and some claims to finish up, and we can call it good for this part of the day. Claimed in the amount of $4,450.
I move to approve claims for $4,450.
I'll second that.
Motion was made and seconded to approve claims in the amount of $4,450. Any public discussion? Any public discussion? Any public discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Okay, claim in the amount of $21,398.56.
I would move to approve the claims in the amount of $21,398.56.
I will second that.
Motion made and seconded to approve claims in the amount of $21,398.56. Any public discussion? Any public discussion? Any public discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries.
Oops.
Claim in the amount of $19,783.65.
I move to approve the claims in the amount of $19,783.65.
I'll second that.
Motion has been made and seconded to approve the claims in the amount of $19,783.65. Any public comment? Any public comment? Any public comment? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries.
Is that it?
All right. I guess we are adjourned until 3 p.m. this afternoon.
Meeting back here at 3.